Every day in the USA, people find themselves in court.
All right, case is entitled, court goes on the Zoom record, State of Kansas versus Taveya Mitchell, 25 CR 169. State of Kansas appears by Greenwood County Attorney Jill Gillette. The defendant, Ms. Mitchell, appears in person and by court-appointed counsel Jorge de Hoyos. This matter does regularly come before the court this date, and it would appear that this matter is for arraignment. And Mr. De Hoyos, does your client wish reading of the charges against her?
So, Judge, in this matter, the parties have reached an agreement in 169. It won't be necessary for the charges to be read, but I would ask you to also call GW 25 CR 211, GW CR 218, all containing the same name, so we might enter plea on all three cases today.
Case is also entitled State of Kansas versus Taveya Mitchell, 25 CR 211 and 25 CR 218, along with case number 25 CR 169. And announcement to the court, Mr. De Hoyos.
So, Judge, in the matter of these three cases, the defense intends to enter a plea of no contest to, in the case of 25 CR 211, count 2, interference with law enforcement, a severity level 8 non-person felony.
Okay, that's interference with law enforcement, severity level 8, person felony.
That's correct, Judge.
All right, thank you. Please proceed.
Judge, in the matter of 25 CR 218, the defendant will enter a plea of no contest to counts 1, 2, and 3.
Count 1 is?
Count 1, 2, and 3 are all the same. Violation of
Okay, excuse me, I did not understand you.
Sorry. All the counts are the same. Violation of a protective order.
Thank you. All right, and what is the severity level?
Those are all Class A misdemeanors.
And that's for counts what now, please?
1, 2, and 3.
And thank you, Mr. De Hoyos. Please proceed.
I made a mistake on that. Class 8, or the severity level 8, is a non-person. Forgive me. Yeah, there's no person felony interference with law enforcement. That's a non-person.
Thank you.
And as a part of the plea, case number 169 will be dismissed by the government.
Thank you, Mr. De Hoyos. And Ms. Gillette, is that the state's understanding of the plea negotiations?
It is, Your Honor. We sent a written plea agreement over to Mr. De Hoyos. I don't know if he has filed it or not, but it was all written out for the defendant to review.
All right, proceeding on with arraignment. Once again, Mr. De Hoyos, does your client wish reading of the charges against her?
The same is not necessary, Judge. No, thank you.
And once again, it's the court's understanding she's entering a plea of no contest in 25 CR 211 to count 2, interference with law enforcement, severity level 8, non-person felony. 25 CR 218, entering a plea of no contest to counts 1, 2, and 3, all violation of a protective order, Class A misdemeanor in each case. And 25 CR 169 is to be dismissed. Is that correct, Mr. De Hoyos?
That is the way we understand it, Judge, yes.
Ms. Mitchell, Mr. De Hoyos has advised the court that you do wish to enter a plea of no contest to case number 25 CR 211, count 2, interference with law enforcement, severity level 8, non-person felony. In 25 CR 218, you wish to enter a plea of no contest to counts 1, 2, and 3, violation of a protective order in each count, a Class A misdemeanor, and case number 25 CR 169 would be dismissed. Ms. Mitchell, is that your understanding of the plea negotiation? Once again, could you repeat that?
Yes, Your Honor.
There are a number of questions that I do need to ask you in order to ascertain whether you are knowingly and voluntarily entering your plea. Ma'am, how old are you?
29,
Are you married or single?
single.
What type of work do you do?
I'm a CNA.
What is the highest education level you have obtained?
Some college.
Are you making your plea voluntarily?
Yes.
Have there been any promises or threats made to you which have influenced you to plead no contest?
No.
I understand there have been certain plea negotiations entered into between your counsel and counsel for the state. Do you understand, even though the attorneys may make certain recommendations in regards to sentence, the decision in regards to appropriate sentence is mine pursuant to the sentencing guidelines for the state of Kansas?
Yes.
When you plead no contest, you surrender and waive certain legal rights you'd otherwise have if you chose to go to trial. Do you understand you have the right to a speedy trial where your guilt or innocence would be determined by a jury, or if you chose to waive a jury, by a judge?
Yes.
Do you understand in such a trial you would have the right to confront the witnesses against you and have them cross-examined by your attorney?
Yes.
Do you understand in such a trial you would have the right to subpoena witnesses who may have information favorable to you and call them to testify in your behalf?
Yes.
Do you understand in such a trial it would be the burden of the state to prove your guilt beyond a reasonable doubt on each element of the charges against you before you could be found guilty?
Yes.
Do you understand the judge and the jury must presume you are innocent until the state proves otherwise, if ever, beyond a reasonable doubt?
Yes.
Do you understand if convicted at such a trial, you'd have the right to ask the court for a new trial, and if denied, would have the right to appeal your conviction and your sentence to the appellate courts of the state of Kansas?
Yes.
Do you understand you're giving up each one of these rights if you plead no contest?
Yes.
Do you understand the sentence which may be imposed?
Yes.
As to case number 25 CR 211, count 2, interference with law enforcement, severity level 8, non-person felony, you could be sentenced anywhere from 7 to 23 months in prison. If you would
Yes.
have a criminal history of one person and one non-person felony or less, there is a presumption you would be placed on probation. If you would have a criminal history of two-person felonies or more, there is a presumption you would be placed in prison. In regards to 25 CR 218, violation of protective order in counts 1, 2, and 3, each a Class A misdemeanor, you could be sentenced up to 1 year in the county jail. As you appear before the court today, I do not know what your criminal history is, if any. You would best know what your criminal history would be. Do you have any question as to the sentence the court may impose?
No.
Do you understand that in addition to the possible sentence and fine, the court will order payment of court costs? I may require to pay restitution for any personal injury or property loss. I may impose administrative costs of a probation program and may require you to reimburse the state for your indigent legal fees.
Yes.
Have you ever been adjudged mentally ill by a court?
No.
Ever had a guardianship or conservatorship set up to handle your affairs?
No.
Are you presently under the influence of any intoxicating liquors or drugs?
No.
Have you had plenty of time to discuss this case with your attorney?
Yes.
Would you like any more time to talk to Mr. De Hoyos about the matters we've just discussed?
No.
Keeping in mind all matters we have discussed, is it still your wish to plead no contest?
Yes, Your Honor.
The court at this time will accept a factual basis from the state. Mr. Lett.
Your Honor, in case 2025 CR 212, Ms. Mitchell appeared in case 25 CR 38, Greenwood County, and gave false testimony, after which she wrote numerous letters and gave numerous statements trying to claim that the report that she gave law enforcement was incorrect for the charges on 25 CR 38, and gave perjured testimony. Later, she had been messaging on an iPad that was recovered during a car chase with Mr. Gordon. And there was messages from her to his mother saying, "You better lie in court like I just did." So she had the intention on June 27th, 2025, of hindering the prosecution of the defendant by giving false statements to law enforcement and courts. On case and that case 25 CR 211, there was a no contact order initiated on Ms. Mitchell with Mr. Gordon as a condition of her bond. Mr. Gordon was in custody of the Greenwood County Jail. On December 9th, Sergeant Mike Cordell was made aware that there were violations happening between Ms. Mitchell and Mr. Gordon using the jail's communication systems. On October 19th, 2025, the account that Ms. Mitchell set up under the name Cynthia Calvin was used to video chat Mr. Gordon with the daughter, and she is coaching him. They are basically answering each other's questions with the minor child with them. On October 28th, there is a second video call where she is driving and had her juvenile daughter unrestrained in the vehicle. She is communicating both with Mr. Gordon directly and through the juvenile daughter. She even says that Cynthia messaged him, which is the account she uses, and told the daughter to tell Mr. Gordon that. They continue to talk and discuss different things, and even discussed that if she says, "We're all going to jail if they see this video." She tells him she took a plea deal. He responds, "They can't lock me up twice. Fuck the cops. I hate them all." The little girl repeats, "Fuck the cops" in the video. Further on count 3, they further continue to have communications on November 9th, and the form of text messages, numerous text messages between the two of them. They continue to use the account under the name of Cynthia Calvin, but it is Ms. Mitchell that is using that account, and it is linked to her cell phone number that is her known cell phone number and the number that she gave on her bond.
No, it is not.
I don't know if it's on her bond, but it's her linked cell phone number. And it's the same number she used for the video chats that she was having with Mr. Gordon.
And Ms. Mitchell, do you know of any reason I should not accept your plea?
No.
And Mr. De Hoyos?
No, I know of no reason why you should not accept her plea.
Ms. Mitchell, the court does find that you are alert and intelligent, that you understand the nature of the charges, and appreciate the consequences of pleading no contest. I further find that you understand the rights you're giving up by pleading no contest. I do find the facts of the case to be sufficient to find you guilty. Case number 25 CR 211, count 2, interference with law enforcement, severity level 8, non-person felony. Case number 25 CR 218, counts 1, 2, and 3, each account of violation of a protective order, Class A misdemeanor. I further find you understand the rights you're giving up by pleading no contest. Once again, the court does find the facts of the case to be sufficient to find you guilty. In case number 25 CR 211, count 2, 25 CR 218, counts 1, 2, and 3. I further find your decision to plead no contest is freely given, and that you have had the advice of a good attorney. With you are well satisfied. Therefore, I do accept your plea of no contest and find you guilty as previously set forth on the record. Subsequently, the court does schedule your case for sentencing. That would be on April 30, 2026 at 9 a.m. April 30, 2026 at 9 a.m. Immediately after the hearing, I do order that you telephone court services to set an appointment for the pre-sentence investigation report.
Okay.
That number is 316-322-4153. 316-322-4153 in order to schedule a pre-sentence investigation interview. In the interim, the court does retain you on the bond that you have previously posted. I do order you to stay in contact and communication with Mr. De Hoyos and your bail bondsman. Keep them both advised at all times, your current address, telephone number, place of employment.
Okay.
Any other matters to come before the court, Ms. Gillette
Not from the state, Your Honor.
and Mr. De Hoyos?
Yeah, just a couple of quick brief things. On the sentencing, do you want the defendant there at the Greenwood County courthouse, or is it okay that she appear by Zoom?
I would prefer that she be at the Greenwood County Courthouse for purposes of sentencing.
Yes, sir. And then secondly, there's a couple names on the no contact list. Tamara Higbee is the grandmother of one of her children. We'd ask that the court remove her from the no contact list as there's no further liability to be concerned in this matter that's been established. Joe, you have any problem with the grandmother coming off?
I don't.
So that's Tamara Higbee by agreement.
The court finds there is no objection by the state to the individual set forth on the record by Mr. De Hoyos coming off the no contact list, and that will be the order of the court.
Okay, and then the second no contact, and Jill, you can oppose this one if you want to. That the Colt Gordon is the father. He's also the co-defendant, I think, in one of the cases. He has a no contact order with her until April 9th, but after that, we'd like her to be able to contact him with regard to their children.
He is the co-defendant in the 2025 CR 18-218. So I'm going to oppose that communication.
The court maintains the no contact order as previously set forth.
That's all I have on this case, Judge. Thank you so much.
There being nothing further to come before the court is in recess. Ms. Mitchell, have a good day. You need to call court services immediately for your appointment.
Okay, thank you.
The judge read out my charges from the state. A no contest plea has sealed my coming fate. Used Cynthia's name on video chats to talk. Violated that protective order round the clock. Now they set my sentencing for April 30th. My lawyer's pleas were met with only grievances. My love's still on that no contact list, you see. Just me and all these felonies.